All right, ladies and gentlemen, let's get started here. I hope to get through this as quickly as possible. I've got an appropriations subcommittee at 2 o'clock, so hopefully I get to make that. Oh, I don't think he's here right now, is he? No. All right, anyway, we're going to start out with, let's see, Representatives Chairman Smith's Coweta Judicial Circuit bill. I see you got some help with you today. If you would, introduce yourself for those online.
Good afternoon. I'm Representative Lynn Smith from House District 70, part of the Coweta Judicial Circuit. Sitting next to me, I'll let our judge introduce himself, and may I recognize another judge?
Sure.
I'm Judge Emery Palmer from the Coweta Circuit Superior Court.
Good to see you, Judge Palmer.
Good to see you, Mr. Chairman.
And our Chief Judge from the Coweta Circuit, John Simpson, is sitting, I think, behind the column.
Oh, there he is.
And so thank you for your time. And actually what I'm presenting to you today is similar to a bill you've already heard, House Bill 77, which created an additional judge. The bill was carried by Gerald Green, and it was House Bill 77. We, too, go through the vetting process. It is challenging to those of y'all who are familiar with that process. And for some point in time, we have wanted to at least get on this top list, and that has happened for us this year. So we have been vetted. One of the comments that the 8th judge request fits with all budgetary considerations. We are sort of southwest of Atlanta and our whole area there. And those of you who have left Atlanta have found our part of the state. So we are growing, and doing our best to keep up with our caseload. And if it is the will of this committee that this bill and this effort goes forward, it would greatly relieve a lot of pressure we feel. That's your layman's viewpoint. So, Mr. Chair, with your permission, may I turn it over to
Please.
Judge Palmer? Thank you.
Yeah, thank you, Mr. Chairman, and thank the committee for considering this bill. We have tried a few times to do it, and our circuit is, we have a 5-county circuit, and it really spans a large area. The northern arc of it is really part of metro Atlanta. The southern part is very rural, but our population, and particularly in the criminal arena, the number of cases we have, if you just look at felony criminal cases, we're number 4 in the state in pure numbers of cases based on the last workload assessment that was pre-COVID.
Mm-hmm.
COVID has exacerbated that for everybody, but I don't think the numbers would be a lot different. Atlanta is number 1. Cobb is 2. Gwinnett is 3. We're 4, and DeKalb is 5.
Okay.
And Cobb, Gwinnett, and DeKalb all have 10 judges. We have 7. And we're also doing that over 5 counties. We're the only circuit that has 2 counties with more than 100,000 people, and that number's growing every day. So this will greatly contribute to our ability to move that caseload and ultimately contribute to public safety in those communities in our circuit. So we thank the committee very much. We'd urge you to support the bill. And give us some relief that we need. And again, thank Representative Smith, Tyler Paul Smith, Jay Collins, and David Jenkins, and all the sponsors of the bill very much for their assistance with that. So thank you, Mr. Chairman.
All right. Judge Palmer, I do have a question for you.
Yes.
that was brought up to me.
Sure.
You're going from 7 to 8 with the passage of this bill. And does that create any problems in the selection of a chief judge for your circuit?
No, it doesn't. I mean, the legislation from the 2006 bill that added the 6th judge controls that issue. This doesn't change that. It's the senior judge in time of service.
Right.
And,
Great.
that wouldn't change with this bill.
You've answered the question there.
All right.
Thank you very much. All right. Okay, the wave over here. Any other questions from the committee? Do I hear a motion?
Motion do pass.
All right, got a motion and a second. Any further discussion? All right, all those in favor say aye. Any opposed? All right, bill passes.
Thank you, Mr.
Thank you,
Chairman.
Mr. Chairman.
Y'all very
Members of the
welcome. Good to
committee,
see you,
thank
Judge.
you.
You too.
We didn't beat y'all up,
Thank y'all.
Oh, here?
Let everybody clear out.
Yes, he is.
Wherever you want to go, you want to stay there? Okay. All right, for the remainder of our time here, we're going to have the Rob Leverett Show.
That's a good way to clear the room, Mr. Chairman.
All right, which one do you prefer to start with?
Let's start with House Bill 80 first. I think that'll be the quickest one.
Okay, all
At
right.
least, Lord, I hope it will. I thought it would be quick before rules, too, but my wish was not granted
Right.
that day.
Whenever you're ready.
Let's see. All right, thank you, Mr. Chairman. This is a bill that passed out of committee a week or two ago, and shall we say, my attempt to answer questions of members of the Rules Committee was seed which fell upon rocky ground and found no purchase. If anybody wants to see a colonoscopy without benefit of anesthesia, that was my appearing before the Rules Committee. So they were not terribly persuaded, but I do understand they are agreeable to the bill if it provided some changes are made. And the only change we have made, there's a substitute which is before you. It's LC 491276S. And the only changes appear on page 2 in lines 32, 33, well, former lines 32, 33, and 34. On line 32, which begins of making the declaration, is physically located outside the boundaries. It did say within or outside. We're basically making it just applicable outside the boundaries of the United States, which was a goal of the Atlanta International Arbitration Society. They had hoped we could have it apply both domestically and internationally, but we're taking this as the best we can get, I think, under the circumstances. So it would not change anything about the need for a sworn statement within the boundaries of the U.S., but you could use the unsworn declaration if the person signing the declaration was physically located outside the boundaries of the United States. And we also there was a phrase at the end of that, in that paragraph, said whether or not the location is subject to jurisdiction in the United States or this state, and that's been stricken. So the language will read as you see right there, which is, well, actually, they did not strike that. That was the intention. So I think we would like to have that. I feel like that should be stricken. I didn't talk to alleged counsel, but to me, if you leave that in, I don't think it makes any sense. So I think you would need to strike whether or not the location is subject to as well.
Where was that at?
Line 33, I'm sorry.
33. Okay, I see
Whether or
it
not the
now.
location is subject to the jurisdiction.
Yeah, I picked that up this morning in a rush and didn't check it, Mr. Chairman. I'm sorry.
All right.
So I think my request would be that we approve LC 491276S, but with the amendment of striking everything basically after the comma on line 33 and to the end of that sentence, but keeping the period.
Okay. Any questions from the committee? You have a question?
I'm just trying to think. I was thinking some of our ambassador residences and things, aren't those subject to the jurisdiction of the United States? Some of our embassies? So wouldn't that be why we would need the clarification?
I wouldn't. I'm not sure I understand the.
I guess I'm trying to figure out why we need to strike whether or not the location is subject to the jurisdiction of the United States or this state, because there are areas outside of our state boundaries which the United States still maintains jurisdiction over. I thought, like our embassies, and so that's where I was kind of confused as to why we need that language. Why we need to strike it.
Right, okay, well, it could be, and perhaps legislative council might comment. There may be a reason that we kept that in that I'm not aware of.
I would say a belt and suspenders approach, in as much as it is drafted, whether or not, it essentially covers all eventualities and all possibilities. So I don't know that there's any harm.
So no
in keeping it
amendment.
there because it's kind of an either or. And to Representative's point, there may be some benefit in keeping it for.
Oh, I see, okay, all right, I understand now, I'm sorry. All right, so yeah, that would be, that's certainly fine with me. I just want to make sure I stand up to my commitment that we're going to make it apply just extraterritorially to U.S. jurisdiction, sure.
All right. And everything else is
That
Wait.
was the only change.
the only
to my
change,
knowledge.
okay. All right. Any other questions from the committee? Do I hear a motion? Second. Hear a motion and a second. Any discussion of that? All right, hearing none. All those in favor say aye. Aye. Those opposed say aye.
Aye? No. You said aye, you said whether, anyway.
Well, they can say aye.
I said aye, I said aye.
Like sign, I guess I should have said.
Yeah.
Okay, all right. The bill passes.
Thank you, and thank you, members of the committee.
He's got it. You need a clean copy.
Got it.
Got it.
We didn't make any changes.
All right. You may proceed to your next bill.
All right, thank you, Mr. Chairman. I'm assuming that's 186.
Yes,
I think
sir.
that was next on the agenda. To members of the committee who were here last year and those who were not, this committee passed out of this committee, and it ended up becoming law, the State and Superior Court Appellate Practice Act, which dealt with appeals from lower courts like probate courts and or quasi-judicial bodies like zoning boards or tree commissions or magistrate courts to a superior state court. There is a procedure in law where you can appeal from one of those courts to a court that normally is a trial court, not an appellate court, but it sits as an appellate court on that kind of thing. And that the law was somewhat confused in that area, and there was a process called a petition for certiorari, which was not to the Georgia Supreme Court. That was a certiorari to one of those lower courts that was very archaic. It was often referred to as dating from horse and buggy days. It was extremely difficult to understand and to get right procedurally. So as a result, usually appeals from one of those courts got dismissed on very technical grounds, and you didn't get decisions on the merits, which I think was viewed as just not fair and not good. Not a good way to run a railroad in the court system. You want to let cases be heard on the merits. So the Judicial Council spent several years working on sort of making a uniform appeal procedure that would be more easy to understand, that would be a little more intuitive, and is based more on the usual appeal you have from Superior Court to Court of Appeals. You're filing something like a notice, and in this case, it's called a petition for review. So that was a pretty comprehensive bill. This committee spent a lot of time looking on it. We had a number of changes, but that did get enacted. It has not become effective yet. It won't become effective until this July, because we knew since it was such a big bill, we wanted to let it sort of sit out there for a while and have an opportunity to, make any corrections or additions that we needed to this year. That sentence is a good segue into this bill. That's what we're trying to do. I know saying something is a cleanup bill is somewhat damning around here, so I won't say it's a cleanup bill, but this is just intended to catch a few very technical cross-references and places where we left the word petition for certiorari in code in various places. So that's what it's intended to do. And Darren Enns with the Judicial Council was going to just talk to the specific sections in the bill briefly, just and can probably do a better job of answering any questions you may have as to sort of technical reasons. So if I could, Mr. Chairman, I'd like to let him go ahead and testify.
All right. And introduce yourself and then go ahead.
Good afternoon, Mr. Chairman, distinguished members. My name is Darren Entz. I'm the Assistant General Counsel at the Judicial Council's Administrative Office of the Courts. I played a hand in drafting HB 916, which you generously supported last session, and we're pleased that it was unanimously passed in the General Assembly and became law. Due to the comprehensive nature of HB 916, we included 39 conforming and technical amendments, but as Representative Leverett said, a few more similar amendments are needed. The first of which is on lines 13 and 14 of the bill. HB 916 includes a general rule that petition for review must be filed within 30 days of the decision appealed. We added a specific exception in HB 916 for Code Section 485311 that because that code section includes a settlement conference requirement, that would throw off the timeline. Subsequently, we've noted another deviation from the 30-day rule in Code Section 44756, which provides that in a landlord-tenant dispossessory proceeding, the petition for review must be filed in 7 days, not 30. When drafting HB 916, we adhered to the principle of maintaining the status quo to the maximum extent possible outside of Chapters 3 and 4 of Title V. And as Court of Appeals presiding Judge McFadden, who supervised the drafting of the bill, said, if it ain't broke, don't fix it. That's what we were trying to do. So we're proposing a general exception here to accommodate any other code sections like 44756 or 485311 out there that deviate from the 30-day deadline to, again, maintain the status quo for that section.
Let me pause you right there.
Yes, sir.
Ma'am, with the camera,
I'm sorry.
House rules don't allow that unless I approve it ahead of time. So if you would, please. Thank you.
Thank you. Our next amendment is on lines 27 and 28. Here we're just changing the nomenclature from certiorari and de novo proceeding to petition for review. And the next one on line 35, we're adding petition for review here and maintaining the reference to certiorari because cert is still available in the context of the Court of Appeals and the Supreme Court for this particular code section. On page 3, line 45, we're striking cert and because it was replaced by petition for review procedure. And finally, an effective date of July 1st, 2023, which matches HB 916. And that is a quick run through of the bill. If you have any questions, I'm happy to answer them.
Any questions by the committee? Excuse me. All right. Don't hear any questions.
All right, very good. And while I'm up here, I wouldn't miss a chance. The Judicial Council has created a training video on HB 916 that we're posting to our website, and it will be available for CLE credit and also continuing judicial education.
Thank you. All right. This, I think, is the first time this bill's been up for a hearing. Is that correct?
Yes, sir.
All right. And we don't have anybody on the sign-up sheet, but there's a good number of folks here. And if there's anybody that wants to speak to the bill, I'll allow it this time.
Gary Jackson, Municipal Court of Atlanta.
You're going to need to get to a microphone, sir.
Gary Jackson, Municipal Court of Atlanta. I just want to give Darrell Enns the credit. He really wrote the bill, and he should get all the credit. And we take judicial notice of how hard he's worked for 6 years, not only put up with me, but to write this bill, which was just, I think we reduced 39 code sections down to 21. And he is a outstanding lawyer.
It's always best when we can reduce the number of statutes we deal with. All right. Before we go any further, I want to recognize Judge Lawton Stevens, colleague of mine formerly, and
Thank you, Mr. Chairman. I'm sorry I'm late, but the author of the Coyote Judgeship Bill said it would be better if I stayed in the hall to see if it could. I took their advice.
well, it worked. So,
He's on time under the old 3-minute rule. Remember that? Remember that?
all right. Anybody else want to speak to the bill? All right. Hearing none, what's the pleasure of the committee? All right. I got a motion pass, and second. All those in favor say aye. Aye. All those opposed, like sign. Not hearing any. Bill passes.
Thank you, Mr. Chairman. Thank you, members of the committee. I'm just so impressed y'all maintained a state of consciousness through those two presentations of mine.
All right. We're at House Bill 220.
Mr. Chairman,
Yes.
there's a substitute which should be in your pack. It's LC 442278S. And that substitute was, basically reflects some changes that the Georgia Association of Realtors requested, and that we have made. And I would like to just briefly talk about the context in which we're bringing this bill, and then I will talk about the changes that are in the substitute versus the bill as filed, if any committee members want to get that information. And we also have a witness to testify today as well, in addition to me. So there was a decision of the Court of Appeals called Deer Lake Homeowners Association, Inc. versus Brown. It was issued in October of 2021, but appeal was attempted and cert wasn't denied until earlier last year. So that's why we're bringing this before the General Assembly right now. It has to do with enforcement of covenants, that most favorite of topics when it comes to homeowners and property owners associations. In the Deer Lake case, there was obviously there was a subdivision that was subject to a fairly sophisticated, robust set of covenants and a declaration. We don't have a lot of those out in Elbert County, but I understand in many counties around Atlanta they do. And the property owner, it sounds like he may have been absentee. He had failed to maintain the property. The association sued seeking damages, injunctive relief, including fines and attorney's fees and costs and past due assessments. They weren't able to find the owner to serve him, so he had to be served by publication. A default judgment was granted, but the trial court denied the injunctive relief, which would basically have been an injunction either requiring the homeowner to do what they were supposed to do or allowing the association to enter the property to fix the thing. I think in this case it was that, most outrageous of things, the mailbox failure to comply with that. And but the trial court denied relief on the basis that they did have an adequate remedy at law, which was self-help. The covenant itself permitted the association to fix the problem. And so there were some other issues in the ruling, but I think that was the main issue that was of concern to the associations, because going onto someone's property to fix their stuff can oftentimes be rather controversial and can sometimes result in the person taking what they view to be reasonable acts to defend their property. And I think there was an incident within the last year or two where in a case like this, I don't think it was in Georgia, but where someone actually got shot. And so the associations don't like to use self-help unless they have a court order. Then they can get the sheriff to accompany them and try to keep everybody safe. So the goal of this bill, I think, is basically to try to get around this ruling so that injunctive relief can be granted, although there is arguably a legal remedy, which is using self-help. It's not really quite an adequate remedy when you can't get law enforcement to accompany you to the property. So I think that's the main goal of the bill. And we're basically revising the Georgia Condominium Act and the Georgia Property Owners Act, which are both in Title 44. And then the final section is an amendment to just part of the general real property code about acquisition and loss of property that deals with covenants and warranties and deeds. And there's a provision in there. I think that the other witness can testify a little more about that, but that's mainly for, that code section, provides if you get zoning in a jurisdiction, the covenants expire within 20 years of that date, or if you adopt covenants, they expire in 20 years unless they're renewed periodically. And there's a provision in there sort of to deal with associations or that aren't formed under the Homeowners Act or the Condominium Act, so they still have the same protection here. And so what we added in the substitute, in the bill itself, we basically have some provisions that say that the association can pursue adjunctive relief without having exhausted its legal remedies. We did in here at the request of the Realtors Association add language that provides that the association first has to notify the property owner and give them right to cure before utilizing those remedies, unless it's something that presents a danger to life or property, kind of an imminent emergency, something of that nature. And so we basically went through the corresponding sections of the Property Owners Act and the Condominium Act and made those changes. And then also have added the notice provision that was requested by the realtors. So I think that's sort of in a nutshell what the bill is about, and I think we've got a witness here to provide a little more testimony as to the sort of practical effect of that case ruling and
All right.
that sort of
I have
issue.
a question for you, though, I think,
Yes, sir.
before we get to that. Representative Bruce.
Thank you. I was trying to see in here, and I don't have my glasses on, so I may have overlooked it.
You need readers or you need some prescriptions?
Does this require the sheriff to go, or does it allow the sheriff to go?
It actually doesn't address that issue expressly, but that's customarily, like, I know when I have litigation, if you have a situation where you're trying to exercise some remedy and you don't have a court order, if you want the sheriff to accompany you, they usually do not unless there's an order. They don't feel like they're authorized in some civil dispute unless you've got an order. Like if you're going to exchange property in a divorce case and you're supposed to go get things out of the house, usually there is an order because it's domestic cases and they tend to be a little more laden with orders. But if you've got something in a commercial transaction, you generally need to have an order from the sheriff. This doesn't mandate the order, but that is the customary practice I think you'll find in most jurisdictions.
Okay. And the second part of the question, does this bill give more authority for the homeowners association to come on somebody's property than they already have?
I will let the next witness address that, but as I read it, it does not. It's really just making sure that if they have the authority to come on the property, they can get an order to sort of solemnize that right and also use as a means to have a sheriff's deputy present to make sure everybody's safe and no one gets hurt.
Thank you.
Thank you.
Okay. All right. If you would, get right up in that microphone, introduce yourself, and then give us your statement.
Thank you, Mr. Chair. My name is Lanier Coulter. I am a community association attorney. I'm here today on behalf of the Community Association Institute Georgia chapter. In law school, they taught us bad facts make bad law. And I'm here to say there's no question there were bad facts in the Deer Lake case. I've been doing this over 20 years. Wasn't involved in the case, but we're here exactly what was mentioned. We're here to deal with the problem of the statutes, to one point already raised, already said we had all these different available remedies, including injunctive relief. That's in 44.376, 44.3.223. That exists in the statute. What this judge said in that case was, I'm not going to let you have injunctive relief until you attempt self-help, period. And from a safety standpoint, a global ruling like that, do we have to replace roofs or at least attempt to replace a roof? It's not always going on the lawn and mowing. Do I have to go through a condominium unit and remove stuff off a balcony? Years ago, I had a guy, the power company turned off his power. He put a gas generator on his balcony at a high-rise condominium. I got to go through the unit, open the door, hope to not get shot, and pull the generator out before I can go ask for injunctive relief. That's what we're trying to address. That's why we're here. And I want you to get to your committee on time. I'm happy to answer any questions about it. I do think it's a big safety issue, but I don't want to overlook the fact in certain HOAs, it would bankrupt them to try to do, I got to paint 10 houses this year because I'm in a 100-home neighborhood and nobody wants to paint their house. So it just creates logistical problems. The court, the judge, will still have every right to say, I don't think injunctive relief is appropriate. I don't think you get money. I don't think you get attorney's fees. Nothing in this takes away that judge's discretion in every single case. We don't want to touch that. So, thank you.
Okay. Is it Representative Kelly? Is that you? Okay.
Thank you, Mr. Chairman. Just a couple questions to help me just better understand the issue. First, just curious, how many instruments are typically drafted with the notice requirement in them?
I would say it's overwhelming. I mean, I haven't seen a condominium declaration. There's one firm that primarily does those that doesn't have due process and a notice requirement, but for an emergency. HOA documents typically follow suit. The statutory provision, just real quick, we have POAs, condominiums, and just general HOAs. That's the 44,560, and a majority of the community associations in Georgia fall under 44,560. That's why that's in there.
Okay. And I've never been involved in any litigation like this, so previously, when you sought, justice from the court, could you was it a either or could you combine? Like, could you get damages, monetary damages, and injunctive relief, or before was it one or the?
No, and that's an interesting point. In over 20 years, we've never, knock on wood, our firm's ever had a problem getting injunctive relief, money damages. Sometimes you do self-help on some things, but you're not willing to run the risk on other items, so it'll be a combination suit. I did note in the statute, while we're cleaning it up, I'll defer to smarter minds than my own as to whether that should be an and/or on those relief sections, because historically we've always done a combination.
That's what I was curious as I was reading it. The way it seemed like it used to read was you could only get one or the other. And anyway, it seems like we're adding that in, but I just thought practically y'all are probably getting both already, so I just don't.
Yeah, practically, we've, knock on wood, I've never had a problem with a judge saying do you want your attorney's fees and fines, or do you want injunctive relief?
Right.
Which one do you want? I've never had a judge ask the question. They've been open to it. And again, it's still in their discretion on the reasonableness of all those things that we're asking.
Okay, thank you.
Yep.
Any other questions from the committee? Representative Holcomb.
Thank you, Mr. Chairman. I don't think I've ever in my life thought about a connection between a clear and imminent danger and a condominium association. So can you give us some more examples about what that might look like?
Absolutely. So had a 38-story condominium, woman throwing a nice party. She reached into her utility closet, which also had her water shut off and everything else, and she took a broom, broke it, and the water went down 38 floors of damage. We exercised our emergency power to go in there and shut the water off.
Okay.
It's going to be typically some true emergency of that magnitude before. And just to be clear with everybody, we're going to try and notice. It's just going to be phone call, knocking on the door, everything else before we go in on any emergency scenario like that. It's not as though we would forego notice at any level.
Okay. Thanks.
Any other questions? All right, hearing none. Anything else from the two of y'all?
Mr. Chairman, the only thing I would mention to Representative Kelly's question is the basis of that decision was availability of an adequate remedy at law, and so that's the issue we're trying to address here in this bill.
Okay. All right, that it?
That's it. Thank you.
Okay. Again, this is a bill that hasn't been up before the committee before, so I'll ask if there is anyone that wishes to speak to the bill. Not seeing anybody in behind the pole there? No? All right. I think we're good. So what is the pleasure of the committee? All right, have a motion and a second. Any further discussion? All those in favor say aye. Any opposed? All right, bill passes. And with that, that pretty well does our business. To the lady in the back, I apologize for not informing you that these hearings are recorded, and you can go online and get a copy of it if you want to. Thank you very much. You're welcome. All right, I think that's it.